तो सामनाକୁ ଛିଡ଼ା କରନ୍ତୁ।
We will list item number 1 for judgment. ESRF 4/2019 with CRNA 817 of 2019.
In view of the foregoing discussions, we are of the view that the prosecution has failed to establish the charges under section 376AB of IPC, so also section 6 of the POCSO Act. And accordingly, as to whether there is any criminal antecedent against the appellant, whether there is anything adverse against the conduct of the appellant during his detention in jail custody, to which he answered in negative. It is not disputed that the appellant is a married person and having children. No material has been produced before us by the London State Council that there is no possibility of reformation and rehabilitation. Every saint has a past and every sinner has a future, strikes a note of reformatory potential even in the most ghastly crime. Human endeavor should be to hate the sin and not the sinner. There is still life in life sentence and only death in death sentence. Therefore, we are not inclined to impose death sentence for the offense under section 302 of IPC, particularly when we have acquitted the appellant of the charges under section 376 AB IPC, so also section 6 of the POCSO Act. Accordingly, while confirming the conviction of the appellant under section 302 of IPC, we commute the death sentence imposed on the appellant to life imprisonment with a rider that he shall undergo minimum sentence of 20 years, and if any application for remission is moved on his behalf, the same shall be considered on its own merits only after he has undergone actual sentence of 20 years. If no remission is granted, it goes without saying that, as laid down by the Honorable Supreme Court in the case of Gopal Binayak Godse versus State of Maharashtra, reported in AIR 1961 Supreme Court 600, the sentence of imprisonment for life shall mean till the remainder of his life. Sentence for the offense under section 354 of IPC. So far as the offense under section 354 IPC is concerned, taking into account the age of the deceased, which was about 6 years at the time of occurrence, the manner in which she was found on the school veranda in a nude condition with injuries, we impose the maximum sentence of 5 years provided for such offense on the appellant, and also direct him to pay a fine of rupees 10,000 in default, to undergo further RI for 6 months for such offense. Sentence for the offense under Section 363 IPC. The sentence awarded by the London Trial Court for the offense under Section 363 of IPC, that is to undergo RI for a period of 7 years and to pay fine of rupees 20,000 in default, to undergo further RI for 1 year, stands confirmed. All the substantive sentences awarded to the appellant are directed to run concurrently. In case of realization of fine amount, the same shall be disbursed to the parents of the deceased. Victim compensation. The London Trial Court has observed in the judgment that for the purpose of the provision under Section 357A of CRPC, the matter be referred to the District Legal Services Authority, Kotak, for consideration of awarding compensation to the victim, and accordingly sent the extract of the order to the District Legal Services Authority, Kotak, for information. State of Orissa, in exercise of powers conferred by provisions of Section 357A of CRPC, has formulated Odisha Victim Compensation Scheme 2017. If the compensation amount has not yet been disbursed to the parents of the victim, the District Legal Services Authority, Cuttack, shall take immediate steps to pay the appropriate compensation within 4 weeks from today. Accordingly, death sentence reference is answered in negative. Criminal appeal is allowed in part. Before parting with the case, we would like to put on record our deep appreciation to Mr. Ramanikant Patnaik and Mr. Vikas Chandra Parija, Learning Counsel for the appellant, for the preparation and presentation of the case and assisting the court in arriving at the decision above mentioned. This court also appreciates the extremely valuable assistance provided by Mr. Janmejay Katkia, Lenin Additional Government Advocate. मोहम्मद मुस्ताक, आपणको पाखरे थिबा सरकारी वकील आज जो राय प्रकाश पाइला से संपर्क में भल भाव आपन को बुझाई देबे। आपन को ट्रायल कोर्ट दंडित करथिबा दुईटी दफा सेक्शन 376 AB इंडियन पेनाल कोड एवं सेक्शन 6 ऑफ द पोक्सो एक्ट रु कोनोसी प्रमाण न मिलिबारु दोषी साब्यस्त करागला नहीं। या बदल रे आपन को 354 इंडियन पेनाल कोड रे दंडित करागला। ट्रायल कोर्ट आपन को 302 और 363 इंडियन पेनाल कोड रे दोषी साब्यस्त करथिले। या कायम रहिला। 302 दफारे ट्रायल कोर्ट आपन को फांसी आदेश देइथिले। ता बदल रे आपन को आमे आजीवन कारादंड आदेश देउछु। आपनकर रेमिशन दरखास्त 20 वर्ष जेल रे रहिला परे ही विचार को निया जिवो। 363 इंडियन पेनाल कोड पई ट्रायल कोर्ट देइथिबा 7 वर्ष सश्रम कारादंड देश और 20,000 टंका जोरिमाना न दे पारले अधिक 1 वर्ष सश्रम कारादंड देश कायम रहिला। 354 इंडियन पेनाल कोड रे आपन को 5 वर्ष सश्रम कारादंड देश 10,000 टंका जोरिमाना आदेश हला। या न दे पारले अधिक 6 मास सश्रम कारादंड देश भोगियो पड़िबो। समस्त सश्रम कारादंड एका संगे चलिबो। आपन जदि जोरिमाना दाखल करंती तेबे समस्त अर्थ मृत झीर पितामाता को प्रदान करा जिवो।
Please, my lord. Person is also languishing in custody since 2010, more than 14 years.
Pardon, make a mention that the appellant is in custody since 10/6/2016. This is a criminal appeal.
Please, please.
Nice.
Not jail criminal appeal. Accused is in custody since 16 years. I have filed bail.
Please.
My lord, a week before last week, I had also submitted a memo,
All right.
but
We'll see that.
thank you.
Weekly list, fresh admission, item number 6.
I was curious about the list. Fine. Hard admit. Call for the trial court record. Sarja report. Please. Yes, next.
Item 7.
May I please, your lords? It's my lord's custody since 9/12/2015.
All right, it has not been admitted.
Lords.
Is there any different?
No, lords.
All right. Hard admit. Life imprisonment.
Lords.
Call for the trial court report. Interim applications for bail and stay realization of fine to be considered after trial report is received. Deposition copy to be supplied to the learning council for this day. Yes.
Grateful.
Item 8.
May I please go?
Fresh admission.
My lord, present.
Life imprisonment.
Life.
You are admitting the appeal and supply the deposition copy. Interim application shall be considered after receipt of the trial.
Item 9.
This is Mr. Tripathi. It's a life imprisonment. Yes, sir. 302. Life. So both matter. 10. Item 9 and 10. Yes. Yes. 10 also. Admit, call for the trial to prepare. Yes, next.
Item 11.
Item 11, I may be permitted through VC, my lords. My lords, this is the petitioner's second round miscase for bail, my lords. Earlier miscase for bail, that is 303 of 2016, my lords. That was rejected on 28/6/2016, my lords. And in the meantime, the appellant has remained more 8 years inside custody, my lords. Conviction under section 302 IPC, life imprisonment is the sentence, my lords, out of which he has already suffered 9 years and 7 months inside custody, my lords. And in my associate will provide the date chart, my lords, for the kind perusal of the honorable court, my lords. And one copy is to be served to the state, my lords. And in the date chart, my lords, page 3, in the date chart, my lords,
Please.
page 3.
Just a minute. What he says about 9 years, some odd months is in custody. So you produce the custody certificate and also criminal antecedent and other relevant things which you think that what would be the effect of his release on the society. All these things you ascertain and produce. We can take up this matter next week. IN number, this case number
183 of 2017.
17. There is an application for bail. Mr. Rajendra Narayan Rao, Land Counsel appearing through virtual mode, submits that the petitioner is in judicial custody for more than 9 years.
9 years, 7 months, my lords.
9 years, 7 months. He has also filed the date chart for the consideration of the bail application, which is taken on record. Let the Land and Council for the state obtain the custody certificates, also criminal antecedent, if any, against the appellant. And if there is any objection from the state side, if the petitioner is enlarged on bail, looking into the surrounding circumstances, put up this matter on 13th of week commencing from 13th May 2020. Yes.
Item 12.
This really was filed by the Land and Council. Mr. Das, this judgment was pronounced on 27th May 2008. And the appeal was filed in 2016. Of course, delay is there, but you take instruction
We have
whether
also not
he has
received a copy.
preferred any other appeal or not.
We have also not received any copy.
No, copy we can supply it to you, but by the time he preferred that appeal, he was in Circle Jail, Sambalpur. So none appears for the appellant. The impugned judgment is dated 27th May 2008. The stamp reporter has pointed out that there is delay of 3013 days in preferring this appeal. Stop. Land Counsel for the state submits that he has not received the copy of the appeal memo. Let the copy of the appeal memo along with the impugned judgment and copies of the missed cases filed for bail and stay realization of fine be supplied for delay condonation and for dispensing with filing of the certified copy of the trial court judgment be supplied to the Land and Council for the state by the registry. Some copy कर दी इधर. The Land and Council for the state shall obtain specific instruction from the jail superintendent as to whether the appellant has preferred any other appeal, and if so, the status of the same. So let us take it on 20th. You will get some sufficient time. Put up this matter on 20th May 2024. Free copy of the order be handed over to the Land and Council for the state.
Item 13.
Your Lordship, item 13 on behalf of Mr. Akash Bhuya may be urged.
Yes, what do you want?
Your Lordship, I seek an adjournment for a week, Your Lordship.
All right, here also you take instruction about the custody period because it's a 2016 criminal appeal. Akash Bhuya, a prisoner's petition has come.
Yes.
He has filed to engage Akash Bhuya. And Akash Bhuiya is filed is Bhinama. All right. Period the prisoner's petition at flag G, in which request has been made by the appellant to engage Mr. Akash Bhuiya as his advocate. Mr. Bhuiya has already filed Bhinama, which is accepted. The names of other counsel, except Mr. Akash Bhuiya and his associate, shall not be reflected in the causation score. Mention is made on behalf of Mr. Akash Bhuiya for adjournment. Since the criminal appeal is of the year 2016, let the Land Council for the state obtain instruction about the custody period. Produce the custody certificate of the appellant. The next day. The jail is Chodwar. Prisoner's petition has also been received from Chodwar jail, Circle jail Chodwar. Okay. So you want it after summer vacation?
Your Lordship, any week before the vacation.
After. Yes, yes. Before vacation. Okay. So then it will come on 20th May.
Much obliged, Your Lordship.
Item 14.
My pleasure, Lordship. The appellant is in custody for commission of offences under section my lord 376D IPC and 120B of IPC for conviction of life. And
there are a number of matters. Which matter you are moving?
CRLA 721.
First one.
Yes, ma'am.
That is the only matter you are moving.
Yes.
Okay. 7-1. So what
Yes,
sentence has been imposed?
Imposed for life of, and fine of rupees 2 lakhs, ma'am. For offence under section 376.
Please come to the operative portion of the appeal, the judgment.
Page 44, my lord. Running page
44. Yes.
I'm reading the question, my lord.
Your name is Munna Ora.
Yes, ma'am.
Single appellant?
Yes, ma'am.
Okay.
Vishnu Kishan, Prashant Dansana, Ranjan Oram, Munna Oram, and Jayamangal Pradhan to undergo imprisonment for life means the remainder of the person natural life and pay fine of rupees 2 lakhs is in default to undergo RI for 2 years. Each under section 376 TIPC, that is section 120B of IPC.
Okay. Any other sentence?
Yes, my lord. Thereafter, my lord, next page, my lord. RI for 1 year for offence under section 66 of IT Act. 3 years of 66B of IT Act, my.
Okay. Another
323,506, my lord, 6 months imprisonment.
No separate sentence for 120B. Okay. Your bail application was earlier rejected?
No, my lord, this is first time, my lord. Laplace is
just a minute. You have not applied for bail earlier?
No, my lord. This is a death that I have given. The appellant is in custody.
Just a minute. We are checking up whether any bail application has been rejected or not. Have you supplied the deposition copies?
Deposition copy.
No. Please supply. How can you want to argue on merit? What is the period of detention of the petitioner?
Detention, my lord, 2010 2014.
14.
Yes, ma'am.
So supply the deposition copy and you produce the custody certificate and other things like which we have ordered in first one. Which jail? Which jail?
Sambalpur. The meantime, my lord, the appellant is released on parole for a period of 1 year, and the
No,
due
no,
time
let
is
him let him obtain that custody certificate. There the details will be there.
Yes, ma'am.
How much period? CRLA number 721 of 2016. This is an application for the that the land council for the appellant supply the deposition copies of the witnesses to the land council for the state. Who in
in course
terms
of the demand.
you supplied. Who in terms of produce the custody certificate and other things which you have mentioned about criminal antecedent, etc. So it will be listed before vacation or after vacation, Mr. Brown? After vacation. So put up the after.
Before vacation on 20th, my lord, I pray.
Before vacation.
Yes, my lord, 20th.
So let it be on 25, 2020. There are some connected matter anybody's in which matter?
See, 453
Four?
453 of the year 17.
Okay, just a minute.
7 of the year.
Yes, 453.
At least 17.
Here also your bail application was earlier rejected. Okay. So same thing you obtained that just that is CRLA number 453 of 2017. Yes,
Criminal
you are
appeal
for the
639
639.
by 60.
Same model 639. So you think ଅନ୍ୟ ମାଛ ଗୁଡାକ ଖାଲି with the ସଂଗ୍ରାସ୍ୟ ବୋଲି କହିବେ ଆଉ ଦିଟା matter ରହିଗଲା.
Another 475 of 2016.
That is also you.
The appellant already is on bail, my lord.
Appellant
Already is on bail.
Then why it has come? Okay, for it's for stay of realization of fine. So stay
475 of 2016. Joy Mangal Pradhan.
CRLA number 475 of 2016 will exhibit list case numbers 2 is an application for stay of realization of fine. After hearing the land and council for Mr. Das, hearing the land council for the party, there shall be stay of realization of fine pending disposal of the yes. Now, a matter rahila. This is this last one, 7 of 2022. You are there. What is this petition has come? Flag C.
Legality.
Okay. He has written the letter in 23 for change of advocate. You contact it. Also listed on 20. So all these matters are coming up 20th of May 2020.
Item 15.
Application for bail, my lord. Operating part is page 21, my lord. Turning page 21. Paragraph 27.
Is it life imprisonment?
No, 14 years.
14 years it should not come before us.
14 years, my lord.
It is a single judgment matter.
Yes.
Why it has come?
Page 22, your lordship.
Please show that.
Page 22, your lordship. A period of 14 years and to pay fine of 30,000.
Then it has to come before the single bench itself, inadvertently listed.
Aye.
Okay. In view of the sentence imposed on the appellant, the matter be placed before the assigned bench person. Yes.
Item 16.
Please, the lordship, my lord, the punishment is life imprisonment, my lord, and the
There
alleged
are,
offences are, my lord, under
Mr.
section of
Sotwa, there are so many matters. Which matter
7
you
to
are
5, my lord. First one.
first one?
My lord, the alleged offences under 342, 506, part 2, 394, 302, 120p, my lord. IPC, my lord.
Just a
My
minute.
lord, in this case, my lord, the principal accused has been released on bail, my lord.
Please wait.
My lord, can you glance?
What is the sentence imposed here?
My lord, life imprisonment, my lord.
Please
Can
come to the
judgment,
operative
my lord.
Please come to the operative part of the judgment.
My lord, in the place 42, my lord.
42.
My lord. She has specifically stated that Siddhartha was present in the ground
We
floor.
want to, what is the sentence imposed? You are going to the, please
My
don't
lord,
lose your
page, my lord,
patience.
page 108, my lord.
In the second, my lord, CRL 245, there is paper book, my lord.
We are holding 7 to
Huh.
5. That is
Paper book is there, so everything will be on clear.
245.
Huh,
Okay,
245
245 to her. 245 ro paper. Paper book hai. Paper book ka naam hai. पेपर बुक का ये हवा था ना जो यही नहीं बोले यही नहीं so that's the judgment
My lord. Judgment, my lord. My lord, so the convictment.
you please come to the hearing on the question of sentence.
My lord, sentence life, my lord, life imprisonment.
Page 108, my lord.
Acha, so the convicts Bhikkhus want, so this man is you are moving for 7 to 5 Tikka alias Sudanando.
So the convicts one Bhikkhu alias Sunil Pusti, 2 Tikka alias Hudan Das, 3 Munna alias Bijan Kumar Das, 4 Lucky alias Siddharth Shankar Pusti, and 5 Bablu alias Devi Prasad Das are sentenced to undergo RI for 6 months for their conviction under section 342 IPC, RI for 3 years for their conviction under section 506 part 2 IPC, to undergo RI for 5 years and to pay up a fine of rupees 5,000 in default to undergo RI for 6 months for their conviction under section 394 of the IPC, to undergo RI for 2 years and to pay a fine of rupees 5,000 in default to undergo RI for 6 months for their conviction under section 25(1)(b)(a) of the Arms Act, to undergo RI for 4 years and to pay a fine of rupees 5,000 in default to undergo RI for 6 months for their conviction under section 27(1) of the Arms Act, and imprisonment for life and to pay up a fine of rupees 10,000 only in default to undergo RI for 1 year for their conviction under section 302 IPC each. No separate sentence is awarded to the convicts for the offence punishable under section 120B IPC, as the punishment is imposed on the convicts for their each act of the conspiracy.
What is the name of the deceased?
This is my lord.
Babita.
Babita, the cousin sister.
Sunita.
Yes,
Sunita Prusti.
Sunita Prusti. Date of occurrence?
11/10/2011.
12/10/2011.
FIR was date of occurrence.
Date of
What is the is there any eyewitnesses to the occurrence?
3 eyewitnesses here.
Who are they?
PW6, 7 and 8.
PW6, 7 and 8.
Just 6, 7, and 8. So let us come to one of the eyewitness and see what he has stated again.
PW6 is the mother of the deceased.
Okay, PW6 is the mother of the deceased.
Shall I place it?
Yes, of course.
I know the accused person standing in the dock. My husband is an informant in this case. Deceased Sunita Prusti alias Lisa was my dog bite. The incident took place on 11/10/2011 at about 10 to 10:30 p.m. It was the day of Kumar Purnami. Prior to the incident, a dispute in connection with the landed property was there between my husband and his elder brother Rushikesh Prusty. In connection therewith, on 26/8/2011, while my husband was returning from his loth shop, his brother Rushikesh and son Sunil were found present nearby our house along with two unknown persons, and that the said two unknown person assaulted my husband, where my husband sustained injuries. My husband came to the house and narrated the incident before us. He, along with my brother-in-law, namely Gadadhar Prusty, went to the police station and reported the incident. Basing on the report, the police searched for my elder brother-in-law, Rushikesh, and his son, Sunil, but they remained absconded from the house. Both of them were found coming to the house at some point of time and again escaped to avoid arrest of the police. On the day of the incident, that is 11/10/2011, Rushikesh Prusty came to the house in the evening at about 6:30 p.m. He thereafter extended abuse and hurled threat to all of us to face the dire consequence in case of my husband will not withdraw the report lodged against him. With this, my husband, along with his younger brother Gadadhar, went to the police station to inform the same. The police, having come to our house, apprehended my elder brother-in-law Rusikesh and took him to the police station. Being annoyed with the apprehension of her husband, my co-sister-in-law Kusmalata Prusthi also extended threat and warned that his son Sunil would come and finish all of us. While taking Rushikesh to the police station, the police also called on my husband as well as my brother-in-law Gadadhar to the police station. While my husband and his brother, so also Rushikesh, was in the police station at about 10 to 10:30 p.m., Sunil came along with five of his associates. Sunil is the main assailant, you know. He and his associates confined the tenants inside their house and closed it from outside. Sunil, along with two others, came to the upstairs. They searched for my husband and his brother Gadadhar by hurling obscene abuse, saying that he would finish everybody. Seeing them, my co-sister-in-law Ranjita Prusti, wife of Gadadhar, informed to her husband over her mobile. Seeing Ranjita in mobile, Sunil extended threat to kill and to hand over the mobile and also fired her. To her good fortune, the bullet did not strike on Ranjita. Sunil thereafter dealt a slap on Ranjita and snatched away the mobile from her hand. Seeing the aforesaid action of Sunil, my daughter Sunita protested, saying Sunil as to why he dealt the slap. Sunil saying, who be
खूप म्हणून.
who Bhoni, dealt a leg blow to my daughter Sunita.
Just a minute. This is the deceased.
This is the deceased, Your Lordship.
So
Sunita.
Sunil, okay, yes.
I was standing to the left of Sunita while my daughter Ranjita was standing to her right. To the back of Sunita was standing my mother-in-law. When my daughter Sunita said, Bhikku bhai, what did I do that you dealt blow? Sunil, who was about to leave, returned and fired 3 rounds from the pistol aiming at Sunita. All the 3 firings struck on the person of my daughter, one just below the breast and rest to abdomen. My daughter, having reacted, saying, Bhikku bhai, why did you kill me? And collapsed. Sunil and 2 of his associates ran away. The 3 other associates also went away to the middle of the staircase. We administered water, but my daughter became unconscious. My eldest daughter Sasmita informed my husband about the incident over my mobile. My husband immediately came to the house. My brother-in-law Gadadhar also arrived along with another person. Seeing the incident, my husband became disturbed and started crying. And thereafter, Gadadhar, along with the person who had accompanied him, took my injured daughter to the hospital. At about 12:30 or 1 a.m. in the night, we were informed my daughter to have died in the hospital. My husband and his brother Gadadhar also returned to the house about the same time and went to the police station to report the incident. I have seen Sunil along with the person standing in the dock with white shirt, Sankar Mandal, and check Banyan, who had come to the upstairs. The other 3 persons were present in the stairs. In connection with the incident, there was a TI parade for the identification of the culprits. I had attended the parade and identified 4 persons. During the TI parade, except the accused wearing white shirt, Sankar Mandal, all other persons were present. The TI parade was conducted by a magistrate. The magistrate prepared the report wherein I put my signature. This is the said report marked Exhibit 6, 6.1 and 6.2 is my signature. The cause of the incident relate to the dissension between Hrishikesh Prushti in one side and my husband and Gadadhar in the other side. My father-in-law Bansidhar Prushti and Murlidhar Prushti were two brothers. As Murlidhar Prushti was issueless, he had adopted Hrishikesh Prushti. Then there is no relevant portion of Rashid.
So, what has happened, Mr.? What is your submission?
My lord, the judgment Miller, in judgment Miller, I'm relying Miller, she has specifically stated that Siddharth was present in the ground floor during the time of the firing made by Sunil. And after such firing, Siddhartha along with Hurdananda, the present petition appellant Miller, and Devi Prasad came to the upstairs and created a common son of in the upstairs. Similarly, PW7, the aunt of the deceased, who was also present at the spot Miller. Miller, the Sunil Pushti Miller, he fired Miller. And he has been released on bail. Another religion bail.
Sunil has been released on bail.
But I have given the order Miller.
You supplied a copy to
Already
the State
supplied.
Council. What is this first one? What period you were there?
Already 7 years during the trial, he was on release on bail Miller.
Huh?
During the trial, he was on bail Miller.
Yes.
And after he was a conditional was granted by interim bail for the mother of the at the time of mother he was granted interim bail.
Hmm. Then you surrendered.
My lord.
When you were granted interim bail? 725. 2022. Let us see that order. 18/11. হ্যাঁ 18/11 18/11 তারপরে এক্সটেন্ডেড হলো 16/12 What do you say, Mr. Merit? IA number 2703 of 2023 in the first one, CRL number 725. The Learning Council for the appellant, Vicky alias Sudananda, submits that the appellant was on bail during trial and after conviction, he was released on interim bail. And after availing the same, you surrender at right time. At right time. Placing the deposition of the eyewitnesses, particularly PW6, who is the mother of the deceased Sunita Prushti. It is argued that the main accusation is against co-accused Bikku alias Sunil Kumar Prushti, who stated to have fired gunshot at the deceased Sunita Prushti, which resulted in her death. And the said who accused Sunil Kumar Prushti has already been granted bail by this court in CRLA number 332 of 2017 by order dated 8/11/2023 in IA number 2609 of 2023. Learned counsel for the petitioner files the copy of the bail order of the co-accused, which is taken on record. The learned counsel for the state fairly submitted that the main allegation is against the co-accused Sunil Kumar Prusti. He has not pointed out that the petitioner has misutilized his liberty in any manner during the period of interim bail granted by this court. Considering the submission made by the learned counsel for the respective parties, the nature of overt act attributed against the petitioner as per the statements of the eyewitnesses, period of detention of the petitioner in judicial custody, fact that the petitioner was on bail during trial and after and also interim bail for some period granted by this court. And since the co-accused against whom main allegation is there have been granted bail, we are inclined to release the petitioner on bail allowed. Sub-item just put the condition that he shall not indulge in any criminal activities, violation of any terms and conditions. Yes, any other matter?
Two, my lord. Sub-item 245 CRLA 245.
What is this extension?
Extension, my lord, he has surrendered in time. He was on an interim
You
bail.
don't want to praise this application?
No, my lord. 2767 of 23.
IA number 2766 of 2023. This is an application for extension of the interim bail. Learned counsel for the appellant submits that since the appellant has already surrendered and has been taken into judicial custody, he doesn't want to praise this application. Accordingly, IA disposed of her Northwest. So, IA number 2767 of 2023. So you stand on the similar footing.
My role was I was standing in the staircase.
Okay, no, you were on bail during trial. And have you been? Acha, you are also on interim bail. Same order for you. You are also on bail granted. Yes.
I'm in the sub-item 3, Your Lordship. Appeal number 252 of 2017. IA number 2832 of 2023. I was also.
And
Hello.
And you surrender at right time after
Yes,
availing the.
yes, Your Lord.
So same order. Mrs. Chandana Mishra. Okay.
Tripathi, Your Lordship.
Huh?
My title have changed.
Tripathi.
Yes, sir.
Chandana. So you are appearing. Why the names of other counsel? Let us only your name, or you want to your associate?
Sir.
Who's the other two application? Nobody is there. Just start, Jan. Yes.
Item 17.
May I please, Your Lordship? Appellant is in custody since from the year of 2014, Miller. The appeal is convicted under section 302 IPC and sentenced him imprisonment for life.
Mr. Das, your earlier bail application has been rejected, or no? The first one.
First one.
Okay. So please come to the operative part of their judgment where the sentence.
Miller. It is submitted by the learned counsel for the convict that the convict is a past offender.
Which page, Mr.
Page 24. Hearing on question of sentence.
Acha, okay.
It is submitted by the London Council for the convictee that the convictee is a first offender, is a young and his family is dependent upon him. There is none to look after his minor children. Lenient view may accordingly be taken. The London prosecutor, on the other hand, submitted that, considering the fact of the case, the convict may be severely dealt with, taking into consideration all the attendance facts and the age of the convict. I am the opinion that the following would serve the ends of justice. The convict is sentenced to undergo RI for a period of 2 years under Section 498A IPC, RI for a period of 1 year, and pay a fine of rupees 5,000 under Section 4 of DP Act. He shall undergo imprisonment for life under Section 302 IPC. Sentence shall run concurrent.
So who are you? How you are related?
I am the husband of
Husband. What is the name of the deceased?
This is Niduri. This is the Niduri.
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 Okay. So you are in judicial custody since when?
Since 10/7/2014.
You have never been released on interim.
No.
So have you supplied the deposition
Yes,
copy?
yes.
Yes.
The paper book is ready.
Paper book ready.
So what are the evidence against you?
Evidence is based on circumstantial evidence.
How she died? While she was staying in your house?
Yes, my lord.
What is the cause of death as per the doctor's evidence?
Yes, my lord.
PW10 Miller.
PW doctor is PW10.
Yes, my lord.
Cause of death, fracture of hyoid bone.
Yes, my lord.
Asphyxious ones, homicidal action. So, when the marriage took place?
13 years back.
13 years back.
Any issue out of wedlock?
2 children, 1 son and 1
Daughter.
Have they stated anything about the what happened?
PW1 informant.
No, on that particular day, what has happened? Any children has been examined? Any of
both the children were
they supported the prosecution case?
No. I have glanced to the other.
No, father must have stated about those dowry demands, etc. And also the tertiary, maybe what Mr. Tripathi,
Yes,
which evidence you want to place?
PW1.
Okay, what he has stated.
I am the informant in case my sister Niduri was married to the accused of the village Samadadi about 8 kilometers from our village. Their marriage was solemnized about 13 years back. After the marriage, they lived in the accused house, Samadadi. They were blessed with 2 sons and 1 daughter. After the birth of 1 son and a daughter, the accused quarreled with my sister, asking to bring gold ornaments and a cycle from her parents. He also physically ill-treated her. She told this to us whenever we came to our house. We called meeting in the presence of the villagers of both the village, and my sister used to go back after specifying both of them on the assurance that the accused would not assault her. The meeting were held within a span of about 1.5 years. About 2 years back, the last meeting was held. After the meeting in the morning, my sister went with the accused. The same night, about 10 p.m., one Dandada of Samadhi came and told that my sister was serious and was being taken to the Tumudi Bandha hospital. My brother Santosh and I went to the Tumudi Bandha. On the way of the
Kutamgara,
Rama.
we found my sister dead in the veranda of a clinic of one Hira. She had been bleeding injury on her back, on her head, and a mark of injury on her neck. The accused and his family members were there. On inquiry, the accused told that the deceased had taken poison. The following morning, I went to Tumudibanda police station. I got a report written by the person near the police station. It was read over and explained to me. Finding it correct, I put signature Exhibit 1 is my signature affair.
So there is nothing about this taking poison, etc.
Yes,
It's a
yes.
false statement given.
Yes.
So what about those two children who say what they stated, what happened on that day? They must be present at the time of occurrence. So whether they stated anything.
The doctor was examined as DW2 Miller.
DW2.
DW.
DW2.
Oh, acha, acha, DW.
Yes.
That is Sikha Majieset. I permitted to read. The accused present is my father. Nidur is my mother. We are three brothers and sisters. One brother is older to me and one is younger. My father used to lay bricks.
Stated that fell down and received the injury.
Yes. My mother worked as a laborer outside. About 3 years back, I was in class 2 at Project UP School, Pidamaha, close to our village Samatiradi. My elder brother was class 4 in the same school. About 3 years back at about 7 p.m.
What is your plea in the accused statement? How your wife died and that is a homicidal death?
Yes,
ଦେହ ଖରାପ ଯୋଗୁ ମରିଗଲେ.
No other witness has stated anything about what happened on that particular day.
PW7 and 8 Millard is the material witness.
Ah.
PW7.
What she has stated or he has stated?
Millard.
C. Okay.
Yes. PW7.
Ah.
I know the informant. Nidur is his sister. The accused, who is my neighbor, married Niduri about 12 years back. After marriage, she had been staying with the accused in our village. 2 sons and 1 daughter were born to them. About 2 years back in the evening hours, the accused came to me and told that his wife was behaving absurdly and was also now sitting. I went and found her sitting. On inquiry, she told that her stomach felt uneasy. I advised her to go to the hospital. She was initially reluctant, but when her condition worsened, I asked the accused to remove her to the hospital. Thereafter, he took her to Prutamagad. The following morning, I learned that Niduri had died. I have not been examined by the police in connection with this case.
So it's a different type of plea has been taken. One witness, the daughter has stated something else. Postmortem report is something else.
Another witness is PW8 Miller. Tikeswar Malik, page 54.
Say you get other he versus state. Yeah. It exists. Go to the reference. It does. Mr. Tripathi,
Yes,
there is a division-based decision of this court in Leti alias Jayadev Rai versus State. This was by Honorable Justice D.N. Hansaria, Justice R.C. Pattanaik. So far as this appeal bail is concerned, it stated that if for 3 years they have remained during this appeal period and there is no chance of early hearing. So at the first instance, they have to be released on bail for 3 months and the conduct will be assessed, and if it is found that so if that would not be applicable some for specific types of cases like multiple murders, propriety with murder, rape and murder, bride burning, all these things that will not be applicable. So let him go for, because he has stated that your custody date is from 10/7/2000.
2014.
All right, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 10/7/2014, and the petitioner is the husband of the deceased Niduri, and their marriage was solemnized 13 years prior to the date of occurrence, and they were blessed with one son and daughter. And the case is based on circumstantial evidence. So paper book has been prepared, but the case is not being taken up for hearing, and therefore the petitioner may be directed to be released on bail. The learned counsel for the state opposed the prayer for bail and praised the evidence of the doctor bracket PW10, who has stated that the cause of death was on account of fracture of hyoid bone leading to asphyxia causing death, and nature of death was homicidal. Stop. In the case of Leti alias Jayadev Rai and another versus state reported in 1993 OCR 427, it is held as follows. Quote paragraph number 21. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, we direct the petitioner to be released on bail for a period of 3 months, subject to condition that he shall not indulge in any criminal activities. The learned counsel for the state shall produce the report from the inspector in charge of which police station you are, or you are a resident of which police station. To Tumudi police station, regarding the conduct of the petitioner while on interim bail. Put up this matter on such and such date. Shall produce the surrender certificate. Produce the surrender certificate, then we'll see.
Obliged.
And there is an application for stay realization of fine. Stay realization of fine, it is to be allowed. There shall be stay of realization.
Item 18.
I'm on VC, my Lord,
Yes, Mr. Naik.
my Lord. Here the petitioner is convicted under section 302, my Lord, by 20134 IPC, and he's in custody, my Lord, since 29/6/2030, and the allegation is, my Lord, due to previous enmity, he picked up the Deceased on the very same day by a motorcycle. Thereafter, he was not found. Last seen and the confession of the accused before two witnesses. Last seen witness also, my lord. He, for the first time, he made such a statement in the court.
It's a case based on circumstantial evidence.
Only my yes, my. No, I would say these are the two
Have you
circumstances.
received?
No, my lord. Deposition copy not.
Mr. Naik, you have not served the copy of the deposition. So this list is for entire week. So you can supply during course of the day. Let him go through it. We can take up day after tomorrow from this week.
I am. I'm sorry, I'm serving the question.
We are not passing an order. This matter will be simply taken up day after tomorrow. Okay.
Item 19. May I please your lordship? My lord, here in this case, the present appellant is inside custody since 14/7/2014, my lord.
Yes.
My lord, I'm convicted for the offense alleged under section 302 for life and pay fine of rupees 20,000.
Your bail application was earlier rejected or?
No, my lord.
First time.
First time.
Please come to the operative part of the judgment.
My lord. This
regarding hearing and sentence.
Judgment. Judgment, page 33.
Yes. No, just to come to that portion of the. It's not necessary to place the entire thing. It is 302 for life imprisonment. And fine is one. So, okay. Then any other? No. Okay.
For 302.
So, what is the name of the deceased?
My lord, Paramananda Kurmi. My lord. Paramananda Kurmi.
Paramananda?
Kurmi.
Kurmi. You have received the deposition?
Yes,
please? All right. And date of occurrence is?
My lord, 13/7/2014.
Huh?
13/7/2014, my lord.
So, any eyewitnesses to the?
Yes, my lord. PW3.
PW3. Please come to that. Please place the evidence of PW3.
My lord. I know the informant. I also know the accused standing in the dock named Bhimnag. I also know the deceased. The occurrence was taken place since 3 years back in month of July 2014 at about 9:30 p.m. in front of house of the deceased. At that time, Paramananda asked me to get a table, and at that time, the accused Bhima and his wife arrived there, and Bhima called Paramananda, and a quarrel was taken place. And on my return, I found that both of them were quarreling. When Paramananda sought for the help, I arrived there to separate both the parties, and at that time, the accused Bhima dealt a knife blow on the stomach of Paramananda. Further, the accused also dealt knife blows on the backside, neck, and shoulder of Paramananda. Immediately, the accused Bhima, with his wife, ran away from the spot in a motorcycle. I called the family members of Paramananda, like wife and mother, and shifted the injured to Mondalia Hospital in that night. The injured Paramananda succumbed to injuries. Police examined me in this case.
So, as for the evidence of this witness, you have dealt 3 knife blows. One on the abdomen, the other 2, one on the back of the neck, third is on the shoulder. 3 stab blows. And what is your submission? Who is the doctor who has conducted?
PW24.
PM doctor.
Yes, PW24.
Yes, cartoon, so left arm stab wound. So, homicidal. So what is your submission that is there any criminal antecedent against this man?
No, no antecedent as per the operative. Well, the person is already inside custody.
No, that is one thing, but
My lord.
we can see it, but subject to what you say that instruction is not available.
Not available.
Right. IA number so and so. This is an application for bail. The Learned Counsel for the petitioner submits that the petitioner is in judicial custody since 14th.
Earlier bail rejected me.
Issue.
7/2/2020
I beg your pardon, my lord. There is no. As we are engaged counsel, there is no instruction.
No, no. If any of the learned judge would have been there, the matter would have gone to that court. Since both the judges have already,
Yes.
so that can take over. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on 14/7/2014, and his bail application in IA number 2078 of 2018 was rejected on 7/2/2020. Submits that in view of the period of detention of the petitioner in judicial custody, and since here paper book has not been prepared,
No.
and since paper book has not been prepared, there is no chance of early hearing. The bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and placed the evidence of PW3, the eyewitness to the occurrence. So also the evidence of the doctor PW24 who has conducted the post-mortem examination. In case of so and so, say you let it okay, 3 months bail granted, and they call for a report also. No? Yes.
Obviously. Item 20.
My lord, the appellant is convicted under section 302 and sentenced to a life, my lord. It is custody about 10 years, 3 months, my lord.
What is the date of custody?
My lord, 22nd February 2014, lordships.
Earlier bail application
No,
rejected, not rejected. Sure.
Yes, ma'am.
Okay. So what is the sentence imposed on the
Life, my lord.
for the offense under section
302.
300. No other conviction, only 3 years.
Yes.
The name of the deceased?
This is my lord, Ram Singh Goya.
Ram Singh
Goya. G-U-E.
Goya.
Yes, my lord.
G-A-Y-A.
My lord.
Date of occurrence?
Occurrence, my lord, 20th, 2014.
Please use the mic properly. We are not
Yes,
able to hear.
20th April 2014, lordships.
20th April 2014.
14.
No. 20th February ହେଇଥିବ ଆପଣ ପରା କହିଲେ 22/2 ରୁ ଆପଣ କଷ୍ଟଡିରେ ଅଛନ୍ତି ତ 24 ରେ କେମିତି ଘଟଣା ହବ?
2 my lord.
That you said. And have you supplied the deposition copy?
Yes, my lord.
Okay. Any eyewitness to the
Yes,
occurrence?
PW1 is the eyewitness occurrence.
PW1.
One, yes.
Wife of the deceased.
Yes.
Please come to that. Let's see. Please press it.
Yes, my lord. I am the informant of this case. I know the accused present in the dock. The deceased Ram Singh is my husband. The occurrence took place on Thursday of about 4 p.m. about 2 years and 11 months back. At the time, my husband Ram Singh was standing in front of the house of Rushinath Goya. When he was standing there, the accused arrived riding a bicycle. The accused then dealt a kick blow to my husband, as a result of which he fell down on the ground. The accused then smashed the bicycle on my husband. When I tried to intervene, the accused threatened to take my life. Saying so, he dealt split wound blows on his head and nose. He sustained bleeding injury on his head and nose. He died at the spot. The accused then fled away, leaving the bicycle at the spot. I informed the incident to the village chowkidar, who informed the local police station. Police Babu visited the spot. During spot visit, Police Babu scribed the FIR as per the instruction.
So, sole eyewitness.
Yes, my lord.
And who is the doctor?
PW 18.
I will accept it.
What injury he has noticed? Okay. Head injury is also there.
Yes, sir.
Cause of death is due to vital organ like brain and multiple bleeding injury leading to some.
Cross examination para 5 lords PW.
PW?
5.
Which prover?
PW 1. I was in my house when the occurrence took place. My husband was drunk at the time of occurrence.
Paragraph 5.
Yes.
Okay. Please place it once again.
Yes.
Let us-
Our house is at a distance about 100 meters from the spot. I had given birth to a baby child one day prior to the occurrence. I had already been discharged from hospital. I was in my house when the occurrence took place. My husband was drunk at the time of occurrence.
So what does it mean? Is it house रे माने बाहर छिड़ा ହେଇଥିବ କଣ ଅସୁବିଧା କଣ ଅଛି ଘର ଭିତରେ ବୋଲି ସେ କୋଉଠି କହୁଛି I was in my house all right ତା ଘରଟା ସାମ୍ନାରେ ଇଏ ଥିଲା that's it is to be adjudicated at the so you are in custody for more than 10 years you said.
10 years.
Yes, let him go on interim. Heard the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submit that the petitioner is in judicial custody since 22 to 2014. And the conviction of the appellant is mainly based on the statement of solitary eyewitness PW1, who is none else than the wife of the deceased Ram Singh Gaya. Land Council submits that the evidence of PW1 is not acceptable, and therefore there is good chances of success in the appeal. Land Council for the state, on the other hand, opposed the prayer for bail and submitted that the evidence of PW1 gets corroboration from the evidence of PW18, the doctor who conducted post-mortem examination and opined the cause of death was due to injury to the vital organ like vein and multiple bleeding injuries leading to shock and death. Yes, set up for the outer line art previous counsel for the appellant. Paper book has not been prepared and therefore there is no chance of early hearing. Then you play for that Teti case and grant him bail for 3 months. Yes.
Item 21.
Please, my lord. My lord, here the petitioner is languishing in jail custody since 10/10/2016. My lord, the deceased and the accused both are also related to each other, nephew and
Have you
this.
is it earlier application rejected or first?
No, first time.
Have you supplied deposition copy? Deposition.
This is jail criminal.
All right. So
this is Chanchola.
Just a minute, Mr. Pata. The sole appellant.
Sole appellant.
Okay. So what is the date of custody you said?
10/10/2016.
And conviction is under section
302 only. Life imprisonment.
life imprisonment.
Sir.
What is the name of the deceased?
Chanchola.
Chancholi Sahu.
Chanchola Sahu.
Chancholi Sahu.
Chanchola Sahu.
Okay. Date of occurrence?
Same day, 10/10/2016.
or 10/10/2016. And any eyewitness to the occurrence?
Yes, madam.
Who is
6
it?
eyewitness, 1 to 6, all are eyewitness.
Oh, eyewitnesses. PW is 1 to 6.
Madam, PW5 is the injured eyewitness.
PW5 injured. Let us place that in.
Madam.
Please.
The informant PW1 is the son of my elder brother Vasudev. The deceased Chanchala is his wife. The accused in the dock is the son of Samsundar, my nephew, another son of Vasudev. My house is a distance at about half a mile from PW1. In the last year, Dasara month, at about 4 p.m., I was going to the hospital for the complaint of blood pressure. Since I felt my head reeling, I sat briefly at the house of PW1. At that time, the accused had suddenly pushed his bicycle onto me. I sustained bleeding injury on my head and fell down. When Gajamani tried to take me to the hospital, hearing commotion behind I looked and found that accused dealing Tangia blows on Chanchala, his khudi, he hacked her neck. Thereafter, I was, however, taken to the hospital.
Who is the doctor?
Doctor
PW9.
PW9.
So many blows you have given. 1, 2, 3, 4.
Quarrel is between accused with the PW5. So unfortunately, when the deceased tried to intervene, then she was sustained that injury. One blow.
One blow.
One blow. Tangia blow. On his vital part and neck.
Please see the number of injuries. One blow. There are 4 injuries caused. Neck and chopped wound. So 4 injuries caused.
Sir.
And cause of death was acute hemorrhage due to sudden spotting of blood from the arteries. External carotid, carotid, 1/3 of the internal carotid veins also, sympathetic chains. So you have remained in custody for 7 years and
7 months.
you have never been released
No.
on interim.
No.
What do you say? So you call for the criminal antecedent. IA number. Why have you filed 2 interim application for bail? There is only one appellant, you said.
Only one appellant.
Please see your one is IN number 8 of 23, and the second one is 26.
Because this is, my lord, this is a transfer brief. I have filed another.
So
it can
one
be
is to
permitted to withdraw. Permitted.
Which one? That
Last one is filed by me. That is in 23.
So 26 of 23.
23, yes, 26 of 23 filed by me.
Acha, look it up. IN number 26 of 23 not pressed. IN number 8 of 23. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 10/10/2016 and he has never been released on interim bail. Let the learned counsel for the state produce the custody certificate. So also obtain instruction about the criminal antecedent, if any, put up this matter. after ensuing summer vacation.
Fulwani.
କୋଉ ଜେଲରେ ଅଛି କହିଲେ?
Fulwani.
We are just coming.
Item number 22.
Well, in this case, I have not collected that appearing on basis of prisoner person mailer. We'll call them the next two mailer.
Have you got all the papers with you?
No mailer, only was the list and
No.
appear before
You
lots of mailer.
want the judgment copy?
Yes, I want judgment copy in the deposition.
Okay.
The state also. Not
State will also not have. It's a jail criminal appeal. All right. Peer you the prisoner's petition at flag D for engagement of advocate Satyanaran Mishra. You have filed your wakalatnama?
Yes, mailer.
Okay. Mr. Mishra has already filed his vnama, which is accepted. The names of other counsel shall not be reflected in the cause list henceforth. Mr. Mishra submitted that he is not having the copy of the impugned judgment, and the same may be supplied to him. The state, let the registry supply copy of the impugned judgment to the learned counsel for the appellant, Mr. Mishra, so also learned counsel for the
Judgment
state.
copy is available. Only the deposition copy.
Judgment copy and deposition copy. So let the copy of impugned judgment, so also the deposition copy be provided to the learned counsel for the appellant and to the learned counsel for the state on the deposition copies. Okay. So say you want it before vacation or after vacation?
Before vacation.
Before vacation. We'll take up on 20th of
Mailer, I pray mailer. Other 21. Mailer on 20 may not be available mailer.
No, that will be in that cause list for 20 and 21. If you have any difficulty, ask one of your associate so that it can be taken off.
Yes, mailer.
Item 23.
Well, in this case, it is the first bail application. The petitioner is convicted under section 302, life and 5,000 fine, and under section 201, 7-year conviction and 5,000 fine.
Please come to the operative part of the judgment. Let us see. Okay, it is 302 life imprisonment, fine 5,000 in default to suffer RI for swan. 201, 7 years RI, fine of rupees 5,000. Okay. So, what is the date of custody you said?
My love, 14th August 2016.
14th August 2016. What is the name of the deceased? Have you received the deposition copies?
Niranjan Mudi.
Niranjan Muli alias Jhanturu.
Niranjan Muli alias Jhantu.
Jhanturu.
Jhanturu, okay. Date of occurrence?
Date of 13/8/2016.
13/8/2016. Any eyewitness to this?
No. Yes.
No eyewitness.
One PW16, he has said that he has seen the occurrence, but court has not accepted it.
Disbelieved it. So what are the circumstances then?
Extrajudicial confession is there.
Extrajudicial confession before whom?
Before the villagers.
Okay.
And last scene also there.
Last scene.
And it's corroborated with the opinion of the doctor also.
Doctor.
PW15.
Doctor is PW?
15.
What is the cause of death as per the doctor's evidence?
That is shock combined effect of neurogenic and hemorrhagic. On shall I place the relevant?
No, just relevant portion. Huh?
On 14/8/2016,
Hmm.
when the accused made a declaration that he committed the murder in the village meeting in presence of so many villagers, so as the then ward member
Mrityunjay
ex-
Mrityunjay
no,
Paricha. Mrityunjay Paricha.
Paricha Kajari Gomango.
We say in the village meeting it is stated that he met it. And what about last scene? PW3.
PW7 and PW16 also.
No, just one witness. What?
About 6 months back, the accused and deceased both went to their field with some.
You are placing which evidence?
PW3.
Three, okay, 6 months back, yes.
For paddy transplantation. Then about 10 a.m. in the morning, being ex-ward member of village heard that Niranjan dead body was found hanging from a corda tree, which is about 1 kilometer away from our village.
Okay.
On hearing so, I along with the village rushed to the spot and saw the dead body. Found that both legs of the dead body in folding condition were touching earth. Then the paternal brother of the deceased monarch said.
So if they were going together to for paddy transplantation, so what is the motive behind the anything?
Both are that is the finding. They have friendship also.
You are in custody for about
7 years,
7 years.
9 months.
The IN number 175 of 23. This is an application for bail. The Land Council for the petitioner submitted that the petitioner is in judicial custody since 14/8/2016. Occurrence in question took place on 13/8/2016. Case is based on circumstantial evidence. And the main circumstances are extrajudicial confession before the villagers in a village meeting on the last scene of the appellant in the company of the deceased. The Land Council further submits that the evidence on record do not form a complete chain so as to unerringly point towards the guilt of the accused, and there are good chances of success, and therefore the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and placed the evidence of PW1, a witness to the extrajudicial confession, so also PW3, the witness to the last scene. He also placed the evidence of the doctor, bracket PW15, who was stated to have noticed antemortem injuries on the person of the deceased and stated that the cause of death is shock, which was the combined effect of neurogenic and hemorrhagic. In case of Leti versus state, আমি ତାଙ୍କୁ ଡାକି ଦେଇଛୁ ସେଟା କରିଦେଇକିନି 3 ମାସ ବେଲ୍ ଦେଇଦେବେ ସରେଣ୍ଡର କରିବା ରିପୋର୍ଟ ହେଲା ଯାହା ହବ। Yes, next.
24.
May please, Madam.
Just add one thing, that there is no chance of early hearing. Paper book has not been prepared. There is no chance. It was the submission of the appellant counsel to start with. Okay.
The appellant conviction undergo RI for life for offense 302 and for 10 years
3761 of IPC and 7 years for under section 32V of SC and ST.
Have you supplied the deposition copy to the state?
Deposition copy is
Yes, my
available,
lord.
your lordship.
Huh?
Deposition copy is here supplied, but SC/ST is there, my lord. Notice.
Oh, then notice has to be, it has not been issued notice.
No, ma'am. Only delay was there, it was gone.
Okay. So it requires a notice to be served on the 14A. Do you serve an extra copy? Since one of the offense under which the appellant was found guilty is under section 32V of the SC/ST PO Act. Let an extra copy of the appeal memo along with the imbue judgment and copies of the interim application be served on the Land Council for the state, which will be sent to the inspector in charge of which police station it is, Mr.
Rayagada, my lord.
Okay, no. It is Doraguda police station, Rekhaiji. Please see that judgment.
Yes, my lord. Doraguda police.
Doraguda police station for its service on the informant in Doraguda PS case number 10 of 2017. Matter will state put up this matter on 20th of May 2024. The Land Council for the state shall produce the confirmation letter regarding service of notice on the informant. Please serve the copies.
Yes, my lord.
Yeah.
Item number 25.
After your lordship, my lord, this email.
Yes, Mr. Naik.
A deposition copy not served.
Naik, the State Council submit that the deposition copies have not been supplied. So please serve it so that we can take up day after tomorrow if you want.
Yes, ma'am.
All right. We are just, it will be taken up from this weekly list.
Yes, ma'am.
Okay. Of May 2024.
Item 26.
May I please your lordship?
Yeah.
There is a noting that there is a defect as pointed out by sir.
Defect number 5B. It is mentioned that certified copy of the order dated. So you have not filed the certified copy of the judgment.
Within a week, lordship may proceed after vacation. I will in meantime. I will.
And there is a delay of 61 days. You have not filed perhaps interim application. No, you have filed. It's all right.
Ma'am.
It's all right. The Mr. Pandey, Akshay Kumar Pandey, Land Council for the appellant, undertakes to remove the defect as pointed out by the stamp reporter within 2 weeks.
Ma'am.
Put up this matter after ensuing summer vacation.
Item 27.
May I please note, but this is a transfer brief, my lord. The letter from the prisoner has been given
Where is
to
that
this
letter?
honor, my lord.
Where is the letter?
Not came very place. With the office, my lord. In this section.
In the section it is there.
And I have filed also Okolada with the miscase.
Yeah. Just we are keeping it tomorrow.
Yes, my lord.
Let him obtain that instruction and you please remain present tomorrow.
Yes,
if it is available, we can take up. Prisoner's petition thibo se V nama file korchandi hala. Ne aso kali dakyu. Tomorrow it will be called.
Item 28.
Prisoner's petition for engagement of Yan Panda. Another prisoner's petition along with blank vocal number received regarding engagement of C. Kosturi. Yogeshwar Shah. Single appellant.
Yes, ma'am.
He has One letter he has written to engage Mr. Gyan Panda. Another letter perhaps he has written to engage C. Kasturi and also filed. What is it? Date is not mentioned in the prisoner's petition. When it is the Supreme Court. Mr. Prisoner petition was supposed. So which jail is now? So the prisoner's petition is on.
Mail by submitting mail. That Gyana Panda name wrongly typed. This he is Gyanananda Panda. Therefore, perhaps he is missing the list mail.
No, but thereafter another
petition without the sign. There,
man. Which one? Blank worker. Let him. Let him say whom he wants to engage. See, M Rampur sub-jail latest letter আসছি 2024 ର. So
Gyanananda Panda.
It's all right. Let us hear him that M Rampur କୁହନ୍ତୁ superintendent କୁ his connection. So କାଲି take up କାଲି 10:30 ରେ କୁହନ୍ତୁ ସେ link ରେ ରହିବେ so that we'll directly ask the accused and engage accordingly. Okay. Link CPC କହିବେ link ଦବା ପାଇଁ ହେଲା ସେ
Item 29.
May I please?
हाँ
M Ram.
हाँ M Rampur jail ଅଛି. You just give intimation. We are also giving the link so that he can appear and tell us whom we want to engage. Yes, Mr.
May I please, Lordship?
This is item number 29.
29, Lordship. The application under section 389.
Please use the mic properly.
Under section 389 CRPC, application for bail.
Is what is the sentence imposed?
Your Lordship, the life
Or for the offense under section
302, Your Lordship.
302.
Eugene
So provide the deposition copies so that we can take up day after tomorrow. There is no problem.
Yes,
okay, it will be called from this weekly list day after tomorrow.
Your Lordship, 9th. Your Lordship, 9th.
You want it on 9th. All right, 9th. But supplied during course of the day.
Tomorrow you will actually supply this.
So we call it on 9/5/2020.
Item 30.
Yes,
May I please, my lord? My lord, petitioner is in custody since 7/11/2015, my lord, and convicted for the offence 376(2)(I of IPC for life imprisonment.
7/11/2015,
my lord.
It's a sole appellant.
Yes, my lord.
Okay. What is the conviction and what is the sentence?
Convicted under section 376(2)(I of IPC and sentence him to undergo imprisonment for life, and which shall men be remanded to his natural life and pay rupees fine of 10,000.
Have you supplied deposition copies?
Paper ready.
Oh, paper ready. Have you applied for bail earlier and rejected, or it is the first time you are moving?
The new counsel, my lord.
New counsel.
First time it is.
First time. Okay. So you have remained in custody for about 8 years and some months.
8 years, 5
Who is the
months.
victim?
PW3, my lord.
Page 58, madam. 7 years gone. Who is the mother?
Mother is the accused, my lord. He is absconded, my lord.
No, she stated that mother came and untied her.
Yes, my lord. He is also accused.
And what about the doctor?
Dr. Madam PW 12.
Examine how many days after?
My lord, examined on 8 11 2015, madam.
Date of occurrence?
Next day, madam. 7
Next day.
11.
Nail abrasions and so on. So. What sentence has been provided for that particular offense? 376 2I.
Minimum punishment is 10 years and maximum life.
Let us see that. Two I has been omitted on 21/4/2018. Because of that, separate section was added. That is 376(3) has been added. So when this occurrence took place?
2015, madam.
2015.
Prior to that.
Minimum sentence is 10 years, which may extend to life. Eight years, 6 months. Are the learned counsel for the petitioner, learned counsel for the state? Learned counsel for the petitioner submit that the petitioner is in judicial custody since 7/11/2015, and though paper book has been prepared, there is no chance of early hearing, and the petitioner has got good chances of success. Balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned counsel for the state place the evidence of the victim PW3. So also the Dr. PW?
Dr. PW 12.
PW12. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Hopeless,
He
my
shall
lord.
not try to come in contact with the victim, shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of that.
Hopeless.
Yes.
Item 31.
May I please?
Yes.
The appellants are before my lordship, my lord. The appellant number 1 is the husband of the deceased.
You have, there are how many appellants,
Two
Mr.
appellants.
Mishra? Two.
Two.
You have applied bail for both the appellants?
Both the appellants.
Okay. So what is conviction and what is the sentence imposed?
My lord, under section 30234, convicted for life, and under 498A, RI for 3 years, my lord.
Okay.
498A, 302, 304.
So what is the, both of you are in custody since when?
My lord, the appellant number 1 was in custody since 11/12/2015.
Never released on interim?
No, my lord. And the appellant number 2 was on bail during trial, and after the judgment was pronounced on 21/11/2019, she has been taken into custody.
Okay. What is the name of the deceased?
The name of the deceased is Minna Malik.
And how these two appellants are related to that?
The appellant number 1 is the husband of Minna Malik, and appellant number 2 is the Ali's second wife.
Okay. When the marriage of appellant number 1 took place with that deceased?
My lord, that is in the year 2003, 12 years back, when the occurrence took place.
Any issue out of wedlock?
My lord, 2 daughters, 1 son.
The reason of dissension is because of this illicit affair or what?
No, my lord. It is not illicit affair. She was staying in the house of the.
This appellant number 2 was staying in the house?
Staying.
Okay. So what
Only
is the cause of death?
The cause of death is due to hard and blunt trauma.
Who is the doctor?
Doctor is PW14. But the important witness is PW5. Eyewitness to the occurrence. The son of the deceased.
Son of the deceased.
Right.
Let us see the PW5.
May I take my lordship to the...
Yes, please. Have you supplied deposition copy?
Yes.
Deposition copy, those what they have supplied, those are not the only typing copy, they are not the certificate copy or...
Okay. You want it, Mr. We can supply, there is no problem. Okay. No, you supply the deposition copies. କିଛି order pass କରୁନୁ ପହର ଦିନକୁ we will take off it from this weekly list.
ଗୋଟେ ଦିଟା ଖାଲି ଟାଇପ କପି ଅଛି, ବାକି ସବୁ ଜାକ ସାର୍ଟିଫାଇଡ କପି। ଗୋଟେ ଦିଟା ଖାଲି ଟାଇପ କପି ଅଛି, ଯେ ସାର୍ଟିଫାଇଡ କପି ମିଳି ପାରେ।
You want deposition copy of all or?
Because the main witness PW5 they are telling.
Already you supply. So Mr. Mishra, it will be taken off on 8th of May.
Well.
Item 32.
May I please, Lordship? Convicted under section 302 and sentenced to undergo
deposition copy you have received, Mr.
No, my lord.
I have given my lord.
ଦେଇ ଦିଅନ୍ତୁ ଆଜି ଆଉ ଗୋଟେ ଦେଇ ଦିଅନ୍ତୁ ପହର ଦିନ ନବା। So 8/5/2024.
Item 33.
May I please, Your Lordship?
Yes.
May I address on behalf of Mr. Jaina, Your Lordship? Whether the petitioner is in custody since
Deposition copy available?
No, ma'am.
Supply the deposition copy.
4 persons have been released on bail.
No, supply he has to. If you want claim of parity, he has to examine the evidence. So supply can be taken up day after tomorrow. There is no problem. Or you want anything after?
No, day after tomorrow because
you have got some problem.
The day after tomorrow, Your Lordship.
Yes, yes. So there is no problem. 8 May. But supply during course of the day. Yes.
My Lord, due report.
Item 34.
Mr. Tripathi, you will supply the deposition copy.
Just now.
Yeah.
Item 35.
My lord, item 35, I am just supplying the deposition copy. Let it come
8.
My lord.
No, it is there. It will be there in the weekly list. It will be called.
My lord, it is the jail criminal appeal, my lord. I have collected the deposition.
Okay.
Here I am supplying.
It's all
Just
right.
supplying, my lord.
My Lord, I may be excused. Item 33, Your Lordship, I am not having the certified copies of the deposition. Your Lordship, may I collect the same because of the so that I can serve it to the London AGA.
Okay, it's all right. He is in custody. You supply the 2 sets of copies, one to the state council and other to the. You collect it to your supply.
Oh, bless.
If you have got pen drive also, it can be supplied to you. There is no problem.
Well, I am having the pen drive.
So give him. He will give you the deposition.
My Lord.
Mr. Tripathi, also collect why you will be hard copy will be supplied in
Mr.
every case
Auropa-
if you where you want. Now it is there, so supply. That would be better. Samostang de diyantu pen drive. Yes.
Item 36.
Yes, this is Asha. It's a life imprisonment. P02RI for life. Yes.
Yeah. We have to
Next item. So मैं खाली check करेगा जो life imprisonment. Delay condom. Item number 36. है ना? Hard admit. सारे engage कर देवे. Advocate, Michael Spirit. है ना? Like stamp reporter has pointed out that there is a delay of 297 days, है ना? Since it's a jail criminal appeal and life imprisonment has been awarded to the appellant, we are inclined to condone the delay in filing this jail criminal appeal. है ना? Then admit put IU item number 36. Same order in item number. Offenses like. So item also say delay condone. है ना? And admit and sir engage कर देगा. है ना? Okay. Next.
Item 38.
Yes, Mr. Tripathi. Well, Vishwajit Tripathi କିଏ ଜାଣିଛନ୍ତି? ତା ନମ୍ବର ଅଛି ଦେଇଛନ୍ତି ଭି ନାମରେ କିଛି ନମ୍ବର ମୋର ଅଛି ନା ତ କ୍ଲିୟରଲି ଆସିନାହାନ୍ତି ବ୍ଲାଇଣ୍ଡ delay is there. No, delay ନାହିଁ ଯେ ଭାଇ ସେ ଜଣକୁ ନାଁ ଦେଇଛନ୍ତି ଇଏ କରିବା ପାଇଁ ତାଙ୍କ ପିଟିସନରେ ଲେଖିଛନ୍ତି ବଟ୍ ମୋବାଇଲ ନମ୍ବର ଦେଇନାହାନ୍ତି ସେଇଥିପାଇଁ ଜାଣିଛନ୍ତି ବିଶ୍ୱଜିତ ତ୍ରିପାଠୀ ଜାଣିଛନ୍ତି ତ କୁହନ୍ତୁ ଆସିବେ so yeah, day after tomorrow we are taking up this matter. 8/5/2024.
Item 39.
Son is appellant in custody matter 2010-2014.
What is your good name, learned and counsel? There is a prisoner's petition.
Deepak Ranjan Mishra.
Okay, then it's all right. You have filed Vinama. And have you got the deposition copies with you?
Deposition copy, judgment is there.
And you have supplied to. All right. So it's a case of life imprisonment. Please come to the operative part of that judgment. Let us see.
So the convict Sukhdev Munda is awarded imprisonment for life and also to pay a fine of.
Mike Tacons, just got
So the convict is Sukhdev Singh alias Munda is awarded
No,
imprisonment.
you come to the operative part. Just there is how many appellants are there? One.
Singh.
Sukhdev Singh.
Sukhdev Singh.
Okay.
Two deceased persons. It's a case of double murder.
Acha. Life and 5,000, so on, so okay. 3 years and so on, so for 506 part 2. So what do you say, Mr. Counsel? It's a case of double murder.
My lord, here is in total 14 number of witnesses are there, including the IO and doctors. And who is the independent witness? They are not supported they don't know anything about the case as I stated.
No. First tell us that is there any eyewitness to the occurrence? Or
No.
No eyewitness.
No.
Then how the London trial?
Lawrence trial court convicted this person as he surrendered, the present appellant surrendered before the court. That will be present in.
No, surrender will be contact. Mr. Katkia?
Plus PW 9 was welcome.
PW 9 is here.
Just a minute. It's a case of double murder. Okay. PW 9.
Yes.
PW 9.
The witness is unable to understand or speak Korean and can only understand and speak whole language. Asks the help of interpreter, namely. So and so is able to interpret what the witness wants to state. I am the informant. The deceased Basu Singh is my husband, while the other deceased Renga Singh is my father-in-law. The accused has killed his brother as well as father. The accused, namely Sukhdev Singh, happens to be the younger brother of my deceased husband. The occurrence took place about 6 years back in the evening on one Saturday in the house used by her deceased father-in-law for dwelling purpose. At that time, I was in my house, which is nearby the house of my father-in-law. Hearing halla and crying, I rushed to the spot immediately and found that both were lying on the ground. My husband had sustained cut injuries on his neck, while my father-in-law had sustained injuries on his head above the earlobe. They had sustained such injuries being assaulted by the accused by means of an axe. Both my husband and father-in-law had died at the spot of the injuries sustained by them. When I reached at the spot, the accused and asked him as to why he had assaulted and accused the death of her husband and father-in-law, the accused chased and threatened to kill her. Out of fear, I rushed towards my house. As it was night on the date of occurrence, I could not lodge the FIR. Next paragraph 5. Very important what he has said. That I have lodged the FIR. The FIR was scribed near my house. At the time of assault, no other villagers were nearby. But after the occurrence, the villagers arrived there. At the time I reached the spot, both the deceased had already sustained injuries and were lying on the ground. I have not witnessed the accused assaulting blows by means of an axe, either to my husband or my father-in-law. Police are examining on the next date of incident. Next paragraph. It is not a fact that owing to previous dispute and enmity, I have falsely foisted the accused person in the present case. When I reached at the spot and asked the accused as to why he has killed her husband and father-in-law, and the accused threatened, she out of fear rushed to her house, and at the time the accused also fled away from the spot. So she has seen the accused standing there, and she has asked the accused, though she has stated that exact at the time of exact assault, she has not witnessed that.
But it's not seen the exact occurrence. That not seen the exact occurrence.
No,
so
assault he has not. It has stated that not stated, but your presence was there, and
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 not a
chemical
skill.
examination report, that means the tangia, the weapon of offense has been seized, that carries human blood of origin.
टांगिया कूट मिलला
It has been seized plus
सी तो वेपन धरिकिनी जगह थिला बोली किछ कहूनी अछि कि स्पॉट रे सी वेपन धरिकी थिला बा स्पॉट रे कोनोसी वेपन पड़िथिला खाली कहूची जे से ताऊ टांगिया रे मारथिला बोली कहूची बट नॉट स्टेटेड दैट आई सॉ द axe in the hands of the accused सेमति किछि कहूनी
she is saying she has not seen the exact assault.
हां
But immediately after the assault, she came to the spot and found the accused at the place of assault. And when she asked the accused that as to why you have assaulted or killed my husband and my father-in-law, then she was threatened, and out of fear she rushed inside the house.
what is your submission learned counsel
My lord, here is those are the independent witness. They had not witnessed about regarding this.
इंडिपेंडेंट विटनेस से पूरा निजे कहूची आउ के नथिले पाखरे
Mother.
डाक सुनी न आसिले से तो एकुटिया ता घर पाखरे थिला घर पाखरे घटना हला आ इंडिपेंडेंट विटनेस तो नथिले कोन कोठ आसीबे को जो माने आसीबे से पोस्ट ऑकरेंस विट ये भी निजे भी गोटे पोस्ट ऑकरेंस विटनेस
Mother.
पीडब्ल्यू
9.
पीडब्ल्यू कितने
9. 9.
हां गामा दे
Apart from that, my lord, he was on bail in trial, my lord. He was in bail.
And chemical examination report hospital Feroz. That is the best page.
no say no, we are asking a question that where from that tangia was found whether it was at the instance of the appellant that it was recovered and how the IO got that tangia must be there in the evidence of that IO.
So I was examined at Petrol 24. Is it 14? 14.
Stated anything where from he got that tangia. So they are related to each other.
Pardon?
In the second page of the deposition, IO has stated
Yes.
at 2:30 p.m. I seized the weapon of offense that is tangia having a wooden angle stained with blood from the spot. So spot room milna.
Yes. And that carries the blood of same group.
Oh, that is as per the C report.
C report.
Heard the learned counsel for the petitioner, learned counsel for the state. In view of the evidence adduced by PW9 Gamma the evidence of the investigating officer PW14 that he seized the weapon of offense near the spot where the appellant was present immediately after the occurrence, and the C report that human when this occurrence took place?
Alert 18/10/2014. 18/10/2014.
When you were released on bail?
My lord, I am bail on 20. This is the custody certificate. That is also present in judgment.
Internal page 2 of the judgment. Paragraph running page 4. Paragraph 2. The prosecution story runs as follows.
Paragraph 2.
Yes, please. The prosecution story runs as follows. On 19/10/2014, at 11:30 am, the informant Srimati Gama Singh, wife of Asu Singh, lodged a written report at Koptipada PS alleging therein that on 18th October 2014, at about 6 p.m., her younger brother-in-law, Sukadev Singh, who is involved in illicit preparation and selling of liquor in the house, called his father Renga Singh and brother Basu.
So, no, he was taken into custody. He says that on
2010-2014. That one present in custody certificate I have given.
তাহলে সারেন্ডার হলা কেবে আচ্ছা ইউটিপি ଥିଲେ 6 years 5 months তারপরে six years 5. Hold on. Auditor. The Learned Counsel for the appellant has produced the custody certificate, which indicates that he was on bail during trial for a period of 6 years 5 months, and after the pronouncement of the judgment on 26/10/2022, he has remained in custody for more than 1 year and 6 months. Since it's a case of double murder, let the Learned Counsel for the state obtain instruction about the criminal antecedent, if any, against the appellant. Put up this matter after ensuing summer vacation. Custody certificate is taken on record. Okay.
Item 30.
Yeah, visual accept. The sole appellant is
Condonation of delay.
condonation of
What
delay.
is the sentence conviction?
My conviction on 15th of September 2023.
No, it is life imprisonment.
My lord, life.
For offense under section
302, 457.
What is 91? As pointed out by the stamp reporter, 106 days.
My lord, may I kindly liberal.
Yes, Mr. Tripmere. IA number 456 of 2024. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 106 days in filing the criminal appeal. After hearing the Learned Counsel for both the parties, since it's a case where life imprisonment has been awarded to the appellant, we are inclined to condone the delay. Accordingly, delay is condoned. Part admit, call for the trial court record, interim applications for your filed bail application, bail and stay realization of fine to be considered after receipt of the trial court record. Deposition copy be supplied to the Learned Counsel for this state.
Yes. Highly obliged, my lord, grateful.
Item 31.
Yes, Mr.
Delay
Mahabharata.
of 59 days.
59 days.
Yes.
And is it a case of life imprisonment?
Yes, Your Honor.
Offense under section?
302 and 27 Evidence Act.
Okay.
No, sorry, 27 Arms Act. And
Same order for the data hochi jo delay ta hochi 106 days. Eta hochi 59 days. Eta 59 days hala. So same order. Delay condone admit baki rest of the order same. Yes. It out admission to chiba. Normal admission. Notice. এটা অ্যাডমিশন আসছে মানে এটা লাইফ ইমপ্রিজনমেন্ট হয়েছিল অ্যাডমিট হওয়া নোটিস থাকবে এই পর্যন্ত ও আচ্ছা সেই পর্যন্ত ওকে দেন উইল গো সিরিয়াল ঠিক আছে
42 will taken serially.
हाँ obvious item number 2 number hearing match
এটা বলতে
List item number 2.
I am the respondent in the death reference. I request let the state begin today.
as is you
He is on his way.
keep
Because I am still not well. So they will get well.
okay what is the offense
Princess Millards, the entire gamut of the penal code, as well as the POXO Act and the SC/ST Act. If a lot of people see the paper book.
no about the sentence part just
Yes.
which volume and which page
Lords, your lordship may look at the thicker one. Yes. There is a thick volume and there is a small. There is slim volume.
which
My lords,
one you
my
want
lords may look at the thicker one. Page 17, your lordship may see the charges are there.
17
Yes.
it 76 with the live streaming is very one live streaming very one
360